Welcome, everyone. Thank you for joining the webinar today. We've got an exciting one with myself, Scott. I'm one of the legal solutions consultants here at LegalVision, and we've got Jessica Anderson, who's one of our senior lawyers within the commercial contracts team. Now, part of coming to this webinar today, you do get access to a complimentary consultation when you do finish this webinar, so feel free to look out for that. A couple of housekeeping matters. You'll all receive a recording of this webinar afterwards, and you'll receive all the slides as well. They'll be emailed through to you after the webinar. And then we welcome you to submit your questions within the Q&A box. This should be at the bottom of your screen. If you can't see it, just click on the 3 button and go to more. Yeah, I encourage you to send through some questions that you may have, and we'll look to answer them towards the end of the call. And as mentioned, after this call, you will receive a survey, and we welcome all feedback. You know, we do a lot of these webinars, so we always want to be improving, make sure they're hitting home. And within that box as well, you'll be able to request a complimentary session with myself or one of my colleagues to talk through all things LegalVision and around the business. Now, from here, we've got our agenda here. I'm going to pass over to Jess, and we can look to get the ball rolling.
Thanks, Scott. Excited to be here with you all today, virtually. We've got a lot to get through today. We're going to cover why it's important to get your contract terms right before signing. We're going to look at the juicy topic of indemnities. We're going to cover liabilities and when you can exclude them. I'll talk about intellectual property ownership, commercial obligations, things like scope, price, deliverables, unfair contract terms and when they are void. And I'll also touch on insurance because this is a really common question we get from clients as well. And then after that, we'll have the Q&A. And thank you for submitting questions. I've seen lots come through already. As Scott said, feel free to submit them throughout and I'll try and get through as many as possible. Okay, so why is it important to get your contract terms right? I think my colleagues in LegalVision's dispute resolution team would tell you that reviewing and, if necessary, amending a contract before you sign is one of the most important things you can do to protect your business and to prevent disputes. So it helps to ensure that the contract is aligned with the expectations of both parties, not just the party issuing the contract. And this can help prevent misunderstandings later on. It gives you an opportunity to confirm that both the contract and the other party will comply with any relevant laws and regulations. It'll give you a chance to work out how flexible and scalable this contract is. If you're looking to grow, which most businesses are, will this contract grow with you? Can you change it if need be? Can you get out of it if need be? What's going to happen if there are unforeseen circumstances? Of course, it gives you a chance to confirm all the commercial details, scope, price, deliverables, timeframes, deadlines. Confirm those are realistic and achievable. This can certainly help to reduce any stress around performance issues. And then if negotiated well, it can help to reduce your liability as either the customer or the supplier. It's not just suppliers who can reduce their liability or responsibility. So I'm going to talk you through some of the key clauses that you should be looking at when signing a contract. And when I say signing, I mean not just signing with a signature, I also mean ticking a box to accept the terms. And keep in mind that when you're working out whether to accept or reject a clause, this really involves a balance of how much risk you're willing to take on, how much money you're spending here, how important is this contract to you. So it's good for you as a business to understand those things. And of course, your lawyer can talk you through those things as well. So we're going to get stuck into indemnities first up. I think these clauses are often glossed over due to confusion. And I think because in practice, they aren't tested very often, but they're common. We see them in most contracts we review. You might see wording like pay on demand or hold harmless or compensate for, and this is all a sign that you're looking at an indemnity clause. There is a lot of nuance to indemnities. I don't have 3 hours to talk about that today, but simply they set out how one party agrees to compensate the other from financial harm that they've suffered. It's a direct obligation to pay for loss you've suffered, or I should say a party has suffered. I briefly want to illustrate the differences between liability and indemnity clauses, because this is one of the most common questions we get from clients. So liability clauses are really about limiting or excluding your responsibility under the contract. So for example, our total liability under this contract is limited to $1,000, or we're not liable for lost profits. The indemnity steps in when someone outside the contract gets involved, or where there are ripple effects beyond the direct contractual relationship. So a liability clause might cap your supplier's liability to you, if you're a customer, at $50,000 if they breach the contract. But an indemnity could require the supplier to pay potentially unlimited amounts if a third party sues the customer because of the supplier's defective product. And that cap, that $50,000 cap, that might not apply. So if you're the customer, you might be hoping for wording such as, if I buy products from you to sell on to my customers, but they're defective and they injure my customer, you, the supplier, will cover their claim against me. We do most commonly see suppliers indemnify customers, given suppliers are the party in the relationship taking on the majority of the risk and the majority of the control of the goods and services. But we do also see customers indemnify suppliers. And this is something really important to look at if you're a customer. So we might see an indemnity for a customer's content or data. The wording might say something like, if the customer asks the supplier to print, host, or process content that infringes copyright or defames someone, the customer will cover the supplier's legal costs that the supplier incurs when dealing with that copyright or that defamation claim. We ideally, I'll touch on this later, but we ideally don't like to see customers giving really broad indemnities. There's a couple of examples of indemnities on the screen. What's the risk of accepting an indemnity? Well, they're considered more high risk because they can expose you to potentially unlimited financial liability. And keep in mind that if there is a really broad indemnity in your contract and you're the one imposing that clause, like it might be you indemnify us for breach of this contract, which is very broad. Clauses like that are becoming more uncommon, and they can be unfair contract terms, which would mean they're void, and I'll touch on that below. So if you've got indemnities in your contract and you can't remove them, they can be amended, and there are things that you can do to make the contract less prejudicial to you. So whether you're the customer or the supplier in the arrangement, make sure that any indemnities you give are within your control. If you can, set a maximum financial cap, which establishes that if you are going to pay out under an indemnity under the agreement, it's only up to a certain amount. So the indemnity is caught by that liability cap. Check with your insurer whether they will pay you if you have to pay out under an indemnity. We find that insurance brokers are really willing to answer questions like that. And then we can also add a clause that states that if there is a loss that arises under the agreement, it's going to be reduced proportionately to the extent there are contributions by the other party, so that it's not the case that either party is taking full responsibility for something that both parties contributed to. Okay, exclusions of liability. Unfortunately, you can't exclude liability for absolutely everything. That would probably be completely unreasonable. It might also be an unfair contract term, but there are certain things you can exclude your responsibility for. And so An exclusion of liability clause is an attempt to define and limit the scope of your responsibility. And usually suppliers who are providing the goods and services, they will want to have really nice carve-outs and exclusions to their liability to set out what they are and aren't responsible for. On the flip side, if you're a customer, you want to be looking at what your supplier is excluding liability for. So a really common example of an exclusion of liability is an exclusion of consequential loss. So this consequential loss should be actually defined in the agreement. It should list what types of losses this include. There's no sort of commonly known, well, I suppose there is a commonly known definition of what that includes, but the contract needs to spell it out. So it could be loss of profits, business interruption, reputational damages. These are all indirect and flow-on consequences which a supplier will want to exclude. What's an example of a loss of profits? So you might offer marketing insights to business customers. And then where that customer implements changes in accordance with these insights, but doesn't achieve the results they wanted, this could result in a loss of profits. So the supplier will potentially want to avoid their responsibility there. But of course, it is ultimately commercial. If you as the customer are expecting to pay for improved profits as a result of those services, then that should not be carved out from the supplier's liability. Another example is loss of data. So if you're a customer, check this. Particularly in the software world, I know a lot of suppliers are wanting to exclude responsibility for loss of data. But if a supplier is handling or creating data for you, if data is really essential to this deal, you probably don't want the supplier to exclude liability for loss of data. In other words, you want them to take responsibility for the data. Third-party inputs. This is another area where businesses exclude their liability. So this typically applies where the services of a third party operate alongside the services that the supplier offers. The providing party, the supplier, will ideally not want to take responsibility for those third-party inputs. But it again depends on the actual contract. If the third party is sort of obtaining that license for their customer, you as the customer want to make sure that to the extent possible, you can complain to your supplier for those third-party inputs. So it's really a balance of, are you the supplier or are you the customer in the situation? What are you paying for? How much risk is the supplier agreeing to take on? If you're paying a lot, they should potentially be taking on more risk and responsibility. Okay, intellectual property ownership, another really big ticket one. And I often think that if you're going to look at one clause in a contract, it should potentially be this, whether you're the customer or the supplier. So what is IP? It's really broad. It can include things like patents for inventions, trademarks for distinctive logos or names, copyright for original works of authorship, and trade secrets for confidential business information. So before even getting into the contract, think about what intellectual property is important and relevant for this deal and relevant for this agreement. The IP should be really nicely described and defined in the agreement so that we know what we're dealing with. We're dealing with each party's background intellectual property. We're dealing with new intellectual property. And we also might be dealing with IP that's jointly created. So define and clarify who will own the IP created or used or modified under the agreement, and make sure you outline both parties' rights and responsibilities in relation to the ownership. And if there are specific purposes for which the IP can be used, these should be explicitly stated. So if you're sharing existing intellectual property, so proprietary information, software methodologies, make sure that it states in the contract that you as the sharing party retain those rights. So a common example is if you're sharing design specifications. You might have a clause that says the supplier cannot use the designs to manufacture similar products for the supplier's other customers, or for the supplier's own product line. This prevents, I suppose, another party infringing on your IP or stealing your ideas. I mentioned before, you really need to establish who owns new IP. Are you paying for the supplier to create new IP for you? Are you, as the supplier, agreeing, charging a high fee because you're creating really bespoke IP for your client? So the contract itself actually has the power to dictate who owns the new IP created. And I do think, as I said, this is particularly important where there is some degree of collaboration. So if the supplier is ultimately creating the IP, but there's lots of input from the customer, make sure the contract spells out clearly who owns that new IP created. So another example is where a supplier is manufacturing a new type of biodegradable packaging to the customer's specifications. So any new designs, prototypes, formulas, or technical documentation created during the project will be owned entirely by the customer, even if the supplier's team develops them. And that's a clause you'd probably like to see if you're the customer. Similarly to third-party inputs, you need to cover any third-party IP that might be incorporated into the services or the deliverables. So if you're the supplier, if possible, try and shift responsibility for third-party IP, including software, that's incorporated into the services you provide by stating, we are not responsible for third-party IP. Certainly also make sure that if you're the supplier, you're not sort of taking responsibility. You don't purport to have any licenses for IP that your customer supplies to you. And then if you're the customer, make sure you understand which third-party IP your supplier is licensing to you. Does your supplier have permission to do that? Does your supplier have permission to share that music or that software or data or image assets? So that's a big one. Moving on to commercial obligations. So what are the services being offered or received? And is there a mechanism for making changes? I mentioned up the top, it's important to know how flexible and scalable the contract is. So when you're setting out the services you're providing or receiving, I think it's good to be as specific as possible about the scope and any deliverables. This can certainly limit risk of scope creep. That is where a client is requesting additional services that haven't been included, or I should say clearly included or excluded. If it is a multi-year contract, check if the supplier can increase the fees. We often see an increase by CPI, but check if they can do that automatically or if they need to notify you if they're going to increase the fees. Most agreements usually only permit changes by written agreement in writing, but you can also implement a formal deed of variation if you do need to change the contract. I think particularly if you're a supplier, make sure you understand what information you need to provide the services. So that might be instructions or designs or intellectual property. And make sure that these details are set out in the agreement so that if your customer doesn't provide that information or the information is inaccurate, you're not responsible for any delays in providing services or errors as a result of the information that's provided to you. If you're a customer, have a look at what warranties the supplier is offering. And similarly, if you're a supplier, think about what warranties or promises you're willing to offer. Factor that in based on how much you're charging. You might require specific warranties from the other party. If you're providing services, this could be that your client will provide you with accurate and up-to-date information. On the flip side, if you're the customer, you might require a warranty that the supplier is providing the services with care and skill in accordance with professional standards, or that the services comply with specific laws relating to your industry. So some really common examples of warranties are service performance warranties, non-infringement of IP, fitness for purpose warranties, and merchantability warranties. What is the payment structure? So what are the fees? How often will invoices be issued and when do they need to be paid? Check if there are any interest charges for overdue or unpaid invoices and how debt recovery works. Do you need to pay for any debt recovery fees that your supplier incurs if they're chasing up debts? It is important to note that non-payment of fees is often a breach of contract, and so usually the customer will have an option to remedy that or by paying the fees owing before the supplier can terminate. And then finally, term and termination. So it's really important to know how long the agreement goes for and how you can get out of it. One of the most common questions, again, our dispute resolution team gets is, how can I get out of this contract? Or I even saw some questions come through prior about signing a contract and wanting to get out of it early because they didn't quite understand what they got into, or the services or the products weren't quite right for them. So make sure you know the mechanisms for termination. Does the contract renew automatically? Are you going to be rolling on year on year, or does the supplier need to give you notice before the agreement automatically renews? We do see that many businesses don't think about these things until it's too late. I'll touch on unfair contract terms. I've mentioned this a couple of times so far. So a few key characteristics of an unfair contract term. Term is likely to be unfair if it creates a one-sided advantage that isn't necessary to protect their legitimate business interests and could cause the customer harm, like allowing a supplier to terminate anytime but locking a customer in for years. UCTs, as they're known, can also be hidden in fine print. They can be unclear, making it hard for a customer to know what they're agreeing to. And UCTs are most common in standard form contracts, take it or leave it T's and C's, where one party presents the contract on a take it or leave it basis with no room to negotiate. So if a contract does contain UCTs, the clause could be unenforceable, and the party trying to impose that clause or that contract could be fined. A couple of other examples of UCTs where a customer indemnifies a supplier for a broad range of loss or damage. And I mentioned this earlier, where the supplier doesn't also have to indemnify the customer in that same way. So I'll put this in simpler terms. So it might say, you, the customer, have to cover the supplier for almost any loss they suffer, but they don't have to do the same for you. So if your late payment causes them inconvenience, you pay their costs. But if their faulty equipment shuts down your production line for a week, they owe you nothing. Clearly very unfair, but clauses in contracts do have that effect, and certainly would be an unfair contract term. Another example is where the contract locks a customer into another long term after the minimum period has expired without giving the customer ample time to cancel. So what should you do if you receive a contract that contains UCTs? If you do receive a contract that contains UCTs, you should really assess what impact that clause might have on your business, if the clause is to be included. And then if you think it's going to have a negative impact, try and negotiate the clause to have it removed. Now, I'm going to finally touch on insurance. So insurance brokers are certainly the experts in insurance. They will advise you on insurance types and coverage, but insurance does go hand in hand in contracts. So we like to talk about it. And they certainly go hand in hand with the liability and indemnity clauses, as I've mentioned earlier. So make sure you understand the types of insurance you need to have as either a customer or supplier. You know, we most commonly see suppliers having to have insurance under a contract, but sometimes customers do as well. Also check what the contract says about the insurance you need to hold. So yeah, as I said, the types, the amounts, and make sure you talk with your insurance broker about what your insurance will cover you for. Will your insurance cover you if you have to pay out under an indemnity? Sometimes, despite your best efforts to make a contract more favorable, the other side just isn't willing to accept changes, but you're keen to proceed with the contract anyway. This is where insurance can be really valuable, and it provides a safeguard to protect your business. If the agreement is particularly high risk or high value, your broker might also be able to tailor your insurance policy to your business against the intricacies of the agreement. So I'll hand back to you, Scott.
Yeah, thank you, Jess. Now, if you're interested, we recommend downloading the commercial contracts checklist. You can get it via this QR code, but keep in mind that these slides will be sent out to you after this, after the webinar finishes as well. Now, we've got another webinar coming up, an exciting webinar relating to corporate immigration risks. This is on the 4th of December, 11 a.m. You'll be able to register for that event via this link or via our website as well. Now, we're going to go through the Q&As. So if you've got any questions, put them into the Q&A box. But while you're doing that, I just wanted to give you a little bit of information around LegalVision's membership. Now, by becoming a LegalVision member, you get access to unlimited legal support through our specialist lawyers, and we're there to support you through all your business as usual legal needs. Now, examples of that, what we've been speaking about today, all of your commercial contracts, your document drafting, reviews and amendments, it's an unlimited service through our membership. And we also provide unlimited legal advice. You know, all those questions that you have, all those little 1%ers or those things that you usually wouldn't put past a lawyer due to the cost, you put them through us. It's all included within this membership. We take care of all your intellectual property protections via trademarks and via the commercial contracts there. And we have really quick turnaround times. I will note that we also provide full employment and HR support. Now, the whole idea is that you've got a LegalVision in your corner. You don't have to worry about the cost blowing out. It's like you're having your own little in-house legal counsel. Worth noting as well, if we have any in-house legal counsels on the webinar here today, we also offer a dedicated service to those in-house legal counsels to manage your high volume business as usual legal tasks. So this model is called desk extension. We have our core membership and desk extension, but if you would like to request a consultation on that, you'll be able to do it via the survey after this call as well. Now I'll pass back over to Jess and we'll go through those Q&As.
Great. Okay, we've had quite a few questions come through, a few about dealing with foreign companies. So yeah, I mean, it's obviously great to be dealing with foreign companies. You're reaching a broader market, a broader audience, but yeah, it certainly can be trickier to enforce your rights, and certainly those rights you have against unfair contract terms when dealing with an overseas corporation. You can certainly try, because these rights are available to consumers in whether businesses or individuals who are signing contracts in Australia. So you can certainly sort of try. I do note there's some complexity to this because unfair contract terms regime applies to take it or leave it contracts. So if you are negotiating it, theoretically, we're no longer sort of falling under that unfair contract terms regime, but you could certainly try and argue that that sort of clause is unreasonable and not appropriate in an Australian context. A question about dealing with mediation when dealing with foreign companies. We like to try and, if you are contracting with an overseas company, we like to try and have mediation or disputes dealt with in Australia, if you are an Australian company, so that your Australian lawyers who are familiar with your contract and familiar with Australian laws can handle it. We know that engaging overseas lawyers can really rack up the costs. And so certainly if you have to travel overseas, that racks up the cost. So if possible, it's good for disputes to be dealt with in Australia. But if you do need to pick a neutral jurisdiction, we often see parties pick a sort of commonly known neutral jurisdiction like Singapore for arbitration. Okay, there's a question, can you argue unfair contract terms after you've signed the contract? with large contracts, it is hard to review all the intricacies, and often these things come up well into the project when they try and enforce them. Yeah, I agree. And I mean, I should say this is why it's great to have a lawyer who can point out some of those more prejudicial clauses or those more unfair clauses to you prior to you signing. There's nothing that says you can't try and renegotiate a contract once it's been signed. If both parties agree and both parties want to proceed with the deal after it's been renegotiated, that's great. Certainly, if you as the customer are important to the supplier, you might have a good chance of bargaining. We often see things being resolved really commercially just by chats between the parties. So it's possible, but it is difficult to argue, hey, this was an unfair contract term. But yeah, certainly contracts, I should say, some of the instances where unfair contract terms have been found in T's and C's that have already been signed by especially individuals. So yeah, businesses can be fined after the fact for including UCTs in their contract. Okay. How best to renegotiate a contract when you don't hold the corporate power in the business relationship? Sort of touched on this, but think about offering concessions on clauses that are not as important to you. Work out what's most important to you in this. Are you willing to sort of let go on the indemnity clause if you're not too concerned that that's a risk for you, if you don't see it being very likely that the other party would try and enforce that clause? Whereas maybe IP is super important to you, so that's the clause you're going to focus on, and the rest you can let go. Next question, how can clients best prepare for their engagement with their lawyer? Yeah, I think it's good to, well, certainly supply your lawyer with a copy of the contract or any discussions and communications you've had with the other party. Sometimes these discussions and communications can actually form part of the contract. And so I think it's good if you as a business are aware of what your main priorities are and what your deal breakers are, and that you have a good sense of your budget and your timeline. How do I make sure my IP stays protected in a collaboration or pilot? What common mistakes do early stage businesses make in contract negotiations? Great question. You don't need a fully fledged agreement to deal with IP in a pilot or a sort of beta testing situation, but a simple agreement setting out that you retain ownership and that the other party gets limited access is a really good thing. You might also want to check that they are going to keep that information confidential. I think particularly in a pilot context, you might be testing the waters. You might not be ready to launch this product or share this confidential information. So it's good to know that the other party you're dealing with is contractually agreeing to keep information confidential, and that once you're done with this pilot phase, they'll return all of the IP and the confidential information you've shared with them. And then the second part of the question was common mistakes businesses make in contract negotiations. I mean, certainly signing without having it reviewed, especially for those really expensive deals or those really important deals. Make sure you're not agreeing to unrealistic deadlines. Make sure you're aware of the termination provisions, the termination clauses, so that you can get out of it if you need to and try and negotiate those. There is a question here, which I think would be better handled by our employment team, my colleagues in the employment team, but I'll give it a stab. If I'm a key employee of the business and will be a new employee in the newly merged business, what lines in the contract should I review to protect my rights? Certainly review the role definition and your reporting lines, and make sure, I mean, similarly to commercial contracts, make sure you're aware of any termination or redundancy clauses and any restraints of trade clauses. Yeah, there's a couple of questions coming in about contracts being amended or agreed by SMS or exchange of emails. Yes, a contract can certainly be amended by exchange of emails. I think it's a neat process if you've then marked up the contract to reflect the changes you've agreed on via email and both parties re-sign or tick a box again. That's very, very clean and there's less chance of confusion or disputes down the track. But yeah, you can absolutely agree to amend a contract by email. Make sure you keep a record of those emails and the dates they were sent. In your experience, what are some common mistakes made that lead to the corporate veil being pierced? Yeah, this is one for our corporate team, but certainly mixing, if you mix personal and company finances, I know that's problematic. Trading while insolvent is an obvious one. And if you were to use the company as a sham to avoid your personal obligations, I think that would be one as well. But I think that's one where you should certainly chat to our corporate team about that one. Must insurance underwriters be made aware of their clients' liability, exclusions, and indemnities? Yeah, I mentioned that in the webinar itself. I think it's a really good idea to chat to your insurer about what you're covered for and for them to have a look at the liability and indemnity clauses in your contracts. We often encourage clients to do that. And as I said, most brokers are really happy to give an overview of what your business is and isn't covered for. If you are indemnifying, is your insurer going to step in and pay you for those amounts that you've had to pay? And then they can, as I said, tailor a policy for a specific contract if need be. Please clarify what digital signatures are acceptable or legal. Plus, is there a rule as to who signs first? Yeah, particularly with the advent of COVID, we're seeing digital signatures being used more and more. So many contracts are signed online. So using DocuSign, Adobe Sign, or any of those things are fairly standard for contracts in Australia. There are certain types of documents like deeds that need to have signatures that are witnessed. And then there's a question, plus, is there a rule as to who signs first? No, generally not. It's both parties can sign. You can also have this idea of counterparts where one party signs one version of the contract, the other party signs an exact replica of that contract, and then together those two separately signed but identical contracts form one signed agreement. What are key signs that you should get legal advice before signing a contract? Get advice if it's high value or if it's important to you, or if you can tell it's a long-term commitment. If you have to offer a guarantee, like a director's guarantee. So this might happen where you're a business purchasing goods or services, but I'll use the example of goods, and your supplier requires you as the director to guarantee payment of the goods if payment isn't made. Really think about if you're willing to take on that responsibility to step in and pay if the business can't pay. And certainly, where possible, try and negotiate those sorts of clauses. What happens if you sign the contract and afterwards realized it contained elements you did not intend? So you do not want to continue with the signed contract. Yeah, look, you're generally bound by what you have signed, but as I said earlier, there's nothing that says you can't renegotiate an already signed contract. Have a look at what the clause says about amending the contract. Email the other party to see what their view is as to amending the contract. Also, if you're thinking of getting out of it, look at what the termination clauses say. How much notice do you need to give? Do you need to give notice? Can you give notice at any time? And does the contract terminate for convenience? Or is there a renewal period that you need to give notice prior to? Is there a standard protocol if two counterparts are, for some version control issue, not identical? Does it go to intent or most recent commonly shared version or other? I don't know of a standard protocol. Yeah, I think you'd be looking at which version both parties have seen, which party, which version was maybe first shared, maybe the latter version that potentially the other party hasn't seen is less likely to be the one that's valid. There's a question earlier, how does an Australian company protect themselves against the US corporations that incorporate in states like Virginia, where the laws and tax are beneficial to US companies? Yeah, really good one. Look, well, as I said, we have a lot of clients who are doing contracts with overseas parties, and this can be a great thing. You might have another party who is based in the US, and they want the contract to be governed by US laws and US tax and all those things, and it's just important for you to go ahead with that deal. Talk to your lawyer about the risks, particularly the tax risks. That is nuanced, and that is something worth speaking to a specialist about. We have a great tax team at LV, but see if possible if the governing law of the contract can be that of Australia, so that at least you know that things like liability clauses, consequential loss clauses will be interpreted as they commonly are in Australia. And then if it's a really big deal, consider getting legal advice from an American, a US-based lawyer who can talk you through the risks and be on your side if a dispute does occur. Okay. What has changed in the latest court precedents that should be considered? I think the biggest one is probably that expansion of the unfair contract terms laws. It's applying to a lot of different contracts under $100,000. And it's really, we're seeing a lot more suppliers update their terms and conditions to make sure that there are no unfair contract terms in them, because we're seeing the ACCC really look at the T's and C's of suppliers to check that there's nothing in there for vulnerable individuals and also consumers, which includes businesses, to make sure that they're not, because often a small business or an individual doesn't have a chance to get legal advice before signing a contract. And so the regulator is checking those big companies' T's and C's to make sure there are no unfair contract terms in there. And then they're asking them to change their contracts. Okay, so when to use AI? Yeah, this is a great one, because AI can be a useful tool when having a look at a contract. I think ChatGPT recently, and perhaps another provider has recently announced that they don't provide legal advice. But AI can be a good initial tool for, I guess if you have a really long contract, pop it in an AI and get it to summarize it for you so that you get a sense of what's going on in there. You could also use it to help identify any kind of missing clauses, anything that's going to be important for you. It's important to set the context. You might say, I'm a customer in this situation, XYZ is important to me. What should I be looking for in this contract, and what might be missing? You could also, I know this can be problematic, but you can also use it to a degree to compare different versions of contracts. So like that earlier question about, what if you have two different versions of the same contract, which one is valid? You can quickly do a check to compare. Obviously, Word has that functionality as well, but you might get a sense of what the risk is. But obvious disclaimer, AI is confident and hallucinates and will often make things up. So yeah, be really wary. Use it as an initial sort of tool, but ultimately, if the contract is important for you or high risk, good to get legal advice. A question about what is the difference between a contract term being voidable in opposed to void, and how often are remedies for breach dictated by the contract itself in opposed to common law remedies? Yeah, so voidable essentially means that it's like putting the parties on notice that this clause could be removed from the contract and not have any effect. Void means, okay, we're agreeing that clause is no longer applicable. And the remedies for breach dictated by contract, yeah, I think I like to talk a lot about our dispute resolution team, because I think they often say that when looking at how remedies for breach are handled, yeah, we look at the contract and we look at what it says the parties need to do if there is a breach. Like there'll normally be a period of time in which the breaching party has to rectify it. The party trying to enforce that clause will usually set out what the other party has done wrong and how much time they have. So yeah, there is that sort of structure or framework in the contract itself, but you can go off script. You can talk commercially about how best to resolve that breach if you're wanting to continue the contractual arrangement. Okay, I think I'll hand back to you, Scott. We've run out of time.
Thank you very much, Jess. And apologies if we didn't answer your question there. That's all we've got time for today, but you'll receive a survey after this webinar, and you'll be able to put any questions in there that we didn't answer. And if you'd like to learn more about LegalVision and the membership, you can put that through your survey as well. But although this is a free webinar, we still value your feedback. So please complete that survey, and we just want to make sure that we're making these as good as we can. But thank you very much for jumping on today, and looking forward to seeing you in the next one. Cheers.